On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He joins us on the program this morning. Roger, good morning. How are you?
I'm fine, Greg, but you've thrown my week off. It's not Monday.
I know. What do we what do we do?
The rest of the week's not going to seem right to me.
Yeah, you're going to be a day off the entire week. And, as you look back and as we do this time of year, you have your top 10 list of some of the cases and the court decisions that have taken place. I'm kind of curious, does a year ever surprise you? Or have you had a year where you look back and go, oh, wow, this, and this happened?
Well, I tell you what, I will have completed coming this August of this year, my 30th year of being on the road and speaking to groups all across the country, 80 to 100 times a year, plus teaching and all the research that goes into this. There isn't a day that I don't wake up that I'm not surprised by what I see. There's always content. There's always developments in ag law and tax. It is so dynamic that it's incredible what goes on during a year. So I'm not sure anything really surprises me. There are trends that we see as we go from year to year and 5-year periods and 10-year periods. There are trends in the law. A lot of that's driven by economic issues, which then give us legal issues. But maybe I was surprised 25 years ago. Nothing seems to faze me anymore.
Indeed. All right. Let's get to it. Let's start with number 10 of what we saw in 2021. And this, we go up to the state of Iowa. And this concerns the public trust doctrine in Iowa itself. Tell us a little more about this case.
Yeah, this is longstanding litigation where the plaintiffs were trying to force the court or get the court to force the legislature to further regulate farming practices based on water quality concerns. And the Iowa Supreme Court, once it got there, said, no, we're not going to do that. We're not going to order the legislature under this public trust doctrine to pass legislation that would force farmers to adopt farming practices that would significantly reduce, as the plaintiffs alleged, levels of nitrogen and phosphorus runoff. The court told them, you need to get people elected in the legislature that will vote for the policies that you want. Don't try and use us to override the legislature or dictate to the legislative branch what they're supposed to do. I think that's a big deal across the country, even though it's one state court opinion, because we've seen other courts deal with this public trust doctrine where the plaintiffs are trying to achieve further regulation of private land via this notion, well, this should be preserved because it's in the public interest. That is a doctrine that came over from England. It was first applied by the U.S. Supreme Court in the mid-1800s, but only to the sea and the territorial waters, never to private property. This is a push that's going to continue, and we've got to watch this. We'll see application of this with respect to water rights, the ability to draw water out of a stream or out of an aquifer to water crops. We'll see it with respect to habitat for endangered species. They're going to use this public trust doctrine to say, well, all that's in the public interest, therefore you got to change your conduct. This is a big case, and I think it'll have, it's just another one of these cases out there where the courts say, no, we're not going to expand this doctrine to regulate private property, and other courts will look at that.
All right, let's go to number 9. This has to do with the IRS, and this looks at regulations on farm net operating losses.
Yeah, in 2021, the IRS gave us a very helpful revenue procedure concerning the carryback period for farm net operating losses. And this, since TCJA was enacted and took effect starting in 2018, prior to that, actually, up through 2017, farmers could carry back an NOL 5 years. And then TCJA came along and said, no, it's only 2 years. And then we got the virus-related legislation in several pieces throughout 2020, and they moved the carryback to 5 years. Well, some farmers are already locked in on a 2-year carryback, and now they would like to go back 5 years. So what we got in 2021 was really helpful guidance from the IRS showing us how a farm NOL could be carried back 5 years by election out of the 2-year carryback. And that's a nice tax help for a lot of farmers in this country.
Let's look at number 8, and we've talked about this many times. This, of course, looking at ag nuisance litigation in North Carolina, and of course, this goes against large-scale large-scale hog confinement operations.
Yeah, it sure does. This is the Murphy-Brown litigation that began a number of years ago, and it spawned many, many lawsuits in North Carolina against hog operations. And the legislature down there amended their right to farm law. Now, every state has a right to farm law. Kansas has a right to farm law. Missouri has a right to farm law. Every state's got one. And what happened in 2021 was when the legislature amended their right to farm law to provide greater protection for farming operations from nuisance lawsuits, it got challenged on constitutional grounds. And the court down in North Carolina this year said it is constitutional, and on all the bases that it was being challenged. And I think the court's decision there is really good guidance for other states that are considering or would want to consider now amending their right to farm laws to provide greater protection for ag operations. Some states, such as Indiana and Florida, had already done so based on the North Carolina amendment. That's now been blessed by the court down in North Carolina, and that I think gives a green light to other states.
As we go to number 7, this has to do with taxes or tax-related developments. This is, of course, in the context of bankruptcy, and this is a federal court determining whether withheld taxes and other prepaid taxes can be deprioritized in a Chapter 12 bankruptcy.
Yeah, that's a big deal. Starting in 2005, there was an amendment made to Chapter 12 bankruptcy that allowed a farmer, and Chapter 12 only applies to farmers in bankruptcy, allows a farmer to deprioritize taxes. And of course, the problem, Greg, during the debt crisis in the 1980s that farmers were facing is that when land values collapsed, that was their primary asset for collateral. They were then upside down, and you'd have a lender that would be pushing them to liquidate some assets, sell off some land. Well, that would trigger taxes. It would trigger recapture depreciation. It would trigger capital gain. And under the priority rules in bankruptcy, those taxes have to be paid first before any other creditor, and they have to be paid in full. That rule change was made in 2005, and it allows the farmer to move the IRS and other taxing authorities' claims to the back of the line and deprioritize them and put them on par with other general unsecured creditors. That's to facilitate a Chapter 12 reorganization plan being approved and keeping the farmer on the farm and farming. Well, the question had been, what if I've got, say, an off-farm spouse that's got a job and taxes are being withheld? There are other prepaid taxes. We might want to throw credits in there. Can those now, when Chapter 12 was filed, be pulled into the bankruptcy estate and deprioritized? Well, there was a case in the Eighth Circuit in 2020 where the Eighth Circuit reversed the trial court and said, no, that doesn't work that way. But then we got an Indiana federal court opinion in the Seventh Circuit in 2021 that kind of says yes, if you have the right set of facts. It's a weird case factually, and there were some other things that should have been done procedurally that weren't. So we've got this, it kind of mirrors the Eighth Circuit opinion, but it really doesn't. And I think there are some lessons there for bankruptcy attorneys that they can take from the Seventh Circuit case to get those prepaid taxes deprioritized. And that's a big deal, especially as we head into 2022, and we could have some pretty rough waters again, particularly with input costs as high as they are. That's going to squeeze a lot of farmers hard.
And we're joined by Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. We're looking at the top 10 as far as ag law and tax cases in 2021. And, number 6, and you classified it right, definitely a mess in Mississippi. And this involves a large grain elevator and UMB Bank.
Yeah, this broke in the news in November and early December. But what this is a whole bunch of farmers in the Mississippi Delta area that sold their fall harvested 2021 grain to a very large elevator there that they didn't realize was in bad financial shape. UMB was the financier to the elevator. And as soon as all of that grain was in the elevator, UMB called the loans in, which were very large amounts, and essentially put the elevator in bankruptcy. And of course, if you've delivered grain to an elevator and haven't been paid and they file bankruptcy before paying you, you are now an unsecured creditor of that buyer. and you're not going to get paid hardly anything, if at all. And whatever program the state has in terms of bonding or indemnity is not going to go very far at all in making you whole. So there are a whole bunch of farmers here that are in fear of going under if they don't get paid for the sale of their farm crops, fall crops. And the farmers filed a class action essentially for their whole group against UMB Bank on a theory that they misrepresented the status of the elevator and waited until the grain was in to call the loans in when the loans were already, one of them at least, was already due prior to the grain being delivered. I'm not sure how that case is going to come out. I'm not sure it's going to be friendly to the farmers because that's what a lender is going to do in the normal course of things, but we shall see what happens. But Greg, it points out the peril of any time a farmer delivers grain to a buyer and there's a time lag between payment. If that buyer goes under, you are a general unsecured creditor, and you've got to be careful. And there are a couple things farmers can do. They might want to look into escrow accounts, letters of credit, but in any event, try to investigate the financial health of the elevator before entering into any agreements with it for sale of grain.
Number 5 has several spokes on it. This, of course, has to do with Roundup litigation, and there are numerous decisions came out of the Monsanto/Bayer being liable for damages. But the one case you're looking at number 5 had to concern the FIFRA preempting state law concerning Roundup litigation.
Yeah, that's the real big issue in 2021. I think, Greg, you and I can be thankful that we're not the Bayer Corporation that bought this mess. But the big issue that came in 2021 was the Ninth Circuit Court of Appeals dealing with state of California law. State of California says, well, you got to put a warning label that says XYZ on it. And under the Federal Insecticide, Fungicide, Rodenticide Act, that label approval has to be by the feds, the EPA's approval. And the EPA has repeatedly concluded that that warning is not appropriate. So this is teed up for the Supreme Court. The Ninth Circuit ruled against Bayer, Monsanto, and they've asked the Supreme Court to hear the case. On December 10 at conference, the Supreme Court didn't decide whether they would hear the case, but on December 13, they asked the U.S. Solicitor General to file briefs in the case, which I find really, really interesting. That indicates the court has some interest in it, but they are asked to clarify whether FIFRA preempts a state law failure to warn claim when the warning cannot be added to the Roundup product without the EPA's approval. And the EPA has said repeatedly, you don't need this warning label. Big, big issue that's hanging out there.
Number 4 looks at a Supreme Court case on equitable apportionment doctrine applies to underground water. This is really a battle between 2 states and the Supreme Court.
It sure is. The facts involve an underground aquifer that underlied numerous states, including Tennessee and Mississippi. And the question is, who owns that water and can use it, and what happens when one state's withdrawals impact water under another state? What happened specifically here was pumping of water by the city of Memphis allegedly took water from Mississippi, and so Mississippi sued for trespassing, claimed that Memphis had wrongly appropriated their water. Well, the Supreme Court basically said, no, we're not going to hear the case, although they issued an opinion because this lawsuit should have been against Tennessee, not the city of Memphis. The Supreme Court has original jurisdiction when it's a state that sues a state. But then they went on to say, well, if we get this issue teed up correctly or we get a subsequent case, we're going to apply what's called the equitable apportionment doctrine in subsequent cases involving interstate groundwater. But, and here is the key for ag, that means if they use that doctrine, which they said they would, the water would have to be apportioned based on economic value rather than volume. Ag is a high volume per economic value user that has implications when the battle is between ag and non-ag. Ag is high volume use, low economic value. Municipal use is lower volume, high economic value, and they said they're going to apportion water based on economic value. Just think of the battles between cities and ag when you hear that come from the Supreme Court. Keep an eye on that one in the future. That's a huge development.
Also in the Supreme Court, They're saying that the government cannot force private property owners to allow trespassing, and so property takings case is your number 3 case this year.
Yeah, this is a big strawberry farming operation in California, and dealing with a California law that all goes back into the 1970s and Cesar Chavez and the United Farm Workers. California law allows them to come without permission onto a farm's premises for up to 3 hours a day and recruit workers. And they don't have to ask to be there. They have a right to be there. And this went all the way to the Supreme Court. The Supreme Court says that's a per se taking, and that is just as protected as a physical taking is. And I think applied more broadly, the decision is a big victory for farmers and ranchers and other private property owners.
Well, number 2, and these next 2 you could interchange, but the developments involving the Waters of the United States rules.
Well, a lot happened in 2021 on WOTUS. Of course, you had the Trump administration's Navigable Water Protection Rule. That was vacated by a federal court. And then the EPA and the Corps of Engineers said, we're not going to enforce that rule nationwide. And so now a new rule on the definition of a WOTUS is being written. It'll take us back to the 1986 definition, which spawned a whole bunch of litigation. And so expect that issue to stay in the courts for the foreseeable future. And I think what the take home on that one is you're going to have greater regulation under this new rule of private property by the federal government under the nexus test that's been used since 1986 in various ways. Adjacency and tying creek beds and streams to a WOTUS, then that's going to become easier under these new rules.
And number 1, of course, is, well, whatever becomes of Build Back Better, but nonetheless, this has been one that's going in 2021 and still going in 2022.
Yeah, I would have had this as number 1 on my list had the legislation passed. It got through the House, a scaled-down version, but it did not. The Senate did not vote on it. And Ag really dodged a bullet with this one. I think even though the bill that passed the House didn't contain many of the provisions that Ag was deeply concerned about, such as loss of stepped-up basis and the lower federal estate tax exemption and higher capital gain rates, so forth and so on, it still has some provisions that could be troubling for agriculture, including adding on another 3.8% tax on active business income above a certain threshold. The big question going forward is, will any of it pass? Well, if we could read Senator Manchin's mind, Senator Sinema's mind, I could give you a clearer view of that. So that remains to be seen. But there will certainly be attempts to pass portions of it, and we're just going to have to see what happens. But this is one that affects has the potential to affect every single farming operation in the country. That's why I put it number 1 instead of WOTUS. WOTUS affects those sometimes that have water issues. This affects everybody.
And why do I get the feeling that it may be on your list when we have this program a year from now, too?
It might be.
All right. Well, Roger, we're out of time, but as always, appreciate it. And as you mentioned, as you said, and you're right, a lot to talk about, and I'm sure when we're here a year from now, probably about the same, a lot to talk about once again.
Indeed. Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He joins us on the Ag Issues program here on 580 WIBW.